Okay, welcome back. Thank you all so much for being here tonight to help us celebrate Luke's and Claire's achievements, and more broadly the achievements of the Law Review, which continues to live up to its long-standing and very well-deserved reputation as a respected and prominent outlet for legal scholarship. As the proud advisor of Luke Ashworth's note, it is my privilege, I guess, to stand up here for a couple of minutes and bask in reflected glory, as they say. While I am doing that, however, I want to say a few words about Luke and his outstanding note on hedge fund regulation. Now, I certainly don't want to preempt the discussion that's to come, for which we are very fortunate to have two very highly regarded and top-notch commentators. Professor J.W. Verrett of George Mason, and a man who certainly needs no introduction in these parts, our own Professor Lyman Johnson as well. I do, however, want to underscore what an achievement this note is. Luke's note, of course, reflects the merits one would expect of any award-winning paper: a tight, logical structure, a thorough and cogent argument, and sheer facility with the English language, all of which will be readily apparent to Luke's readers. But for those of you not familiar with the subject matter, I want to emphasize what a challenge it is to pull this off with a topic as esoteric and politically charged as hedge funds these days. As you will shortly hear, these are essentially investment pools structured to stay off the regulatory radar screen, meaning that empirical data on their investments and their role in the financial crisis are patchy, to say the least, and that hedge fund regulation as such is literally new legal terrain. The inherent challenges here are substantial indeed, rendering Luke's achievement all the more impressive. Now, this brings me to another great strength of Luke's note, and in my mind, one of the principal strengths. It reflects a scholarly maturity well beyond what can fairly be expected of people within just a couple of years' exposure to the law. This, again, is all the more impressive given the subject matter, I think. Perhaps due to the realities I noted just a moment ago, the debate on hedge fund regulation has, in my humble view anyway, generated a lot more heat than light. Extreme positions abound, yet Luke has resisted the temptation to vilify an easy target, while at the same time resisting the opposite temptation simply to pretend there are no problems here whatsoever. Naturally, reasonable minds can and will differ on what we ought to do with the hedge funds. That, of course, is the occasion for our discussion tonight, and frankly, it's what makes this stuff so much fun. But regardless, Luke's balanced and thorough analysis of such a charged topic is a breath of fresh air, and well worthy of this recognition. For all of these reasons, it came as no surprise to me that Luke's note would win this year's Steinheimer Award. And for much the same reasons, it came as no surprise to me that he's landed a very prestigious clerkship next year with Chief Justice Myron Steele of the Supreme Court of Delaware, which, as many of you will know, is essentially the center of the corporate universe, Delaware being the jurisdiction of incorporation for most U.S. public companies, and the Delaware Supreme Court being the final word on the law that governs their internal affairs. It is my great pleasure to introduce to you Luke Ashworth, who will present his note titled, "Is Hedge Fund Advisor Registration Necessary to Accomplish the Goals of the Dodd-Frank Act's Title IV?" Please join me in congratulating Luke for a job exceptionally well done.
Hi, everybody. I'd first like to thank Professor Verrett and Professor Johnson for making the trip to come here. I'm very honored that you guys agreed to comment on my note and came. Importantly, I'd like to thank Professor Bruner for all of his advice and his help in the note writing process, and also just advice in general throughout my first couple years in law school. As Claire would say, you two are a rock star. I'd also like to thank Brant Stitzer for keeping me on top of deadlines and listening to my ideas. And lastly, I'd like to thank my guest, my fiancée, Jen. I'd like to thank her for, among other things, agreeing to marry me. the title of my note is not very clever. It's just a question. But what you can tell from it is that I'm going to talk about hedge funds, their advisors, and how the Dodd-Frank Act, or a little piece of it, affected them. So what I'm going to talk about today is kind of what a hedge fund is, how they've gone unregulated, what events kind of spurred debate about regulation, and then we'll get to Dodd-Frank. So what is a hedge fund? Hedge funds are hard to define because they're diverse, complex. They often have unique and very secretive trading strategies. Typically, hedge funds refer to the private funds that pool the assets of wealthy and institutional investors to invest and trade in equity securities, fixed income securities, derivatives, futures, all these a very broad range of financial instruments. They're often professionally managed, and they carry high levels of debt, and we'll get into that later often. And so why are they called hedge funds? Back like when the first hedge funds came about, like 1950-ish, they would hedge against market risk by offsetting long stock positions with appreciating values of short stock positions and vice versa, which basically means they were just hedging against market risks or other risks just using different financial instruments. And today they're extremely broad and flexible. Some will focus on country-specific equity markets. Others will focus on industry-specific markets. Some are called like relative arbitrage hedge funds, and they look to exploit pricing inefficiencies among various financial instruments. And they often use like really advanced computer software. This whole small sample just kind of shows you how broad they can be and how flexible hedge funds can be. Now, the size of the industry, as Professor Bruner kind of teased, most of the information comes from the industry itself. So a lot of it comes from industry surveys. So this is all approximate. But today there's around 10,000 hedge funds currently operating and managing around $1.5 trillion in assets or so. So regardless if it's approximate or not, it's large. And most of the legal implications surrounding hedge funds have revolved around the fact that really sophisticated or wealthy or institutional investors have invested in hedge funds, so the government has kind of taken they can fend for themselves kind of attitude, and that's kind of the base of why they haven't been regulated. Predictably, hedge fund regulation and the debate about it has correlated with the growth and the popularity of the hedge fund industry itself. So the more the industry has grown, the more debate about regulations come about. In securities regulation law, there's four big federal securities laws. The Securities Act of 1933, the Securities and Exchange Act of 1934, the Investment Company Act of 1940, and the Investment Advisors Act of 1940 as well. The first three, I'm not going to talk about it much due to time, but hedge funds have avoided registration or any kind of regulation under these three, largely revolving around the same, they can fend for themselves kind of attitude, and they fit into a number of other narrow exceptions. Revolve around the fact that they do private offerings and stuff like that. The one law I do want to talk about is the Investment Advisors Act of 1940, because that's the one big federal securities law that the Title IV of the Dodd-Frank Act amended and changed. This act mainly requires investment advisors to register with the Securities and Exchange Commission, the SEC. And they have to provide certain information. A lot of this is a big anti-fraud statute. And the investment advisors have to register with the SEC, and they can monitor this information and look for red flags. Hedge fund advisors have typically not had to register under this act. They used to argue this private advisory exemption that said if you're managing less than 15 clients, you could be exempt. And they would argue that each hedge fund that they managed was a single client. So, a fund could have like 100, 1,000, however many investors, but if they were just managing 14 funds, they were exempt. And the SEC in the 80s provided a safe harbor that said this was fine. Now, getting into major events that kind of spurred hedge fund regulation or the debate about it, there's two big ones in my note at least. So the first one is the collapse of a massive hedge fund, long-term capital management in the 1990s. LTCM was created by a group of highly reputable financial professionals a couple people had won Nobel Prizes in economics. They're smart people. And when they crashed in 1998, there was over $4 billion in equity in the fund, and they were investing in various bond markets in the world, and they borrowed about $125 billion from various banks to amplify their gains if they were to win or get a bet correctly, but it would also amplify the losses. Well, the bond markets they bet in and the investments they took eventually failed for a number of reasons, and a creditor group, including the Federal Reserve Bank of New York, had to bail them out. And why they decided to bail them out? Because of the reason they thought LTCM posed systemic risk. And this is an overriding theme of my notes, so I'll define it in a lengthy definition. So, systemic risk is defined as the risk that an economic shock, such as a market or institutional failure, triggers through panic or otherwise, either the failure of a chain of markets or institutions or a chain of significant losses to financial institutions, resulting in increases in the cost of capital or decreases in its availability. Now, that's a mouthful. In effect, systemic risk can be paralleled to a domino effect, where there's a trigger event, here a massive hedge fund's collapse, that causes a chain of bad economic consequences to the banks that they had borrowed the money from, and it can bring down these institutions and eventually spread to overall markets. So LTCM's collapse was kind of the first sign that hedge funds could pose systemic risk and have systemic consequences. And so the government put out a couple of reports. Congress introduced a couple bills. The government reports recognized that hedge funds could pose systemic risk, and the two bills kind of wanted to collect more information from larger hedge funds. One of the thresholds was hedge funds managing $3 billion or more in assets. Another one was for hedge funds managing $1 billion or more. And they would collect more information related to systemic risk, like the fund's total assets and their derivative positions, leverage ratios, just information they thought pertinent to the systemic risk. But eventually LTCM was seen as kind of a one-off, and the debate about regulation kind of disappeared. So the next big time where hedge fund debate about regulation came about was around 2003. The SEC held a hedge fund roundtable. This was just after the technology bubble had burst. A lot of people were invested in different technology companies, and investors were looking for other places to put their money. Institutional investors started investing more heavily in hedge funds, and there was also these things called funds of funds, which allowed investors to invest in a variety of different hedge funds, so they were diversified within the hedge fund industry, but could still be exposed to it. And so, like the ordinary investor that's invested in a big institutional investor, like GE or something, that had invested in a hedge fund, was now being kind of indirectly exposed to the hedge fund industry. So SEC thought this was a good time to start and meet about it. Also, for a variety of reasons, the SEC also noted that hedge fund advisor fraud had increased. And so in 2004, they passed a rule that kind of eliminated the exemption, the one fund, one client exemption of the Investors Advisors Act of 1940 that I talked about. And they said you actually have to count the number of people that are investing in the funds. And so you couldn't just do 14 funds, you had to actually count. So virtually this meant that every hedge fund, practically speaking, had to register with the SEC by 2006. But as you can guess, some hedge fund advisors weren't happy about it, so they took it to court. And eventually got a case, Goldstein versus the SEC, eventually got to the Court of Appeals of the District of Columbia, and this rule was vacated. So the hedge funds went back to being unregulated. The hedge fund advisors went back to being unregulated under the Advisors Act. And the SEC didn't appeal this ruling, but they did pass in 2007 a rule 206-4-8 under the Advisors Act, what I just call the Hedge Fund Anti-Fraud Rule. And this rule specifically prevents hedge fund advisors from making false or misleading statements to investors or otherwise defrauding them. And the SEC decided to use a negligence standard for determining liability. And if you take in securities regulation, you know that that's a lower standard than scienter, which involves intent for the catch-all big anti-fraud Rule 10b-5 under the Securities and Exchange Act of 1934. So up until 2007, there's still not much regulation, but they did have this anti-fraud rule. It provided a pretty serious disincentive for fraudulent activity from hedge fund advisors. Now that brings us to the financial crisis of 2009. And for time-constrained, time reasons, and due to the fact that not everyone knows exactly, it's not completely hashed out why the financial crisis came about, all the different reasons, although there are many. But to save time, the financial crisis was a great or a tragic example of systemic risk and systemic failures. You had a lot of linked and interwoven parties, such as institutional investors, banks, hedge funds. They were invested in a wide variety of financial instruments, very complex financial instruments. You might have heard of mortgage-backed securities, collateralized debt obligations, and credit default swaps. And all these were, or a lot of these were tied to the United States real estate market. So when mortgages started defaulting and the United States real estate market started falling, deteriorating, it kind of had that ripple effect and took a lot of these parties down with it. And hedge funds are right there involved too. And for illustrative purposes, one of the kickoff events of the financial crisis, where everyone knew it was extremely serious, two Bear Stearns hedge funds that were highly invested in these collateralized debt obligations linked to the U.S. real estate market collapsed in 2007, and the government had organized a buyout by J.P. Morgan. And that's just one of the examples. So the financial crisis, great example of systemic risk, systemic consequences, and we're still feeling the effects of the recession today. So what did Congress do? Congress, in response to the financial crisis, passed the Dodd-Frank Act to promote financial stability in the United States markets. And the Dodd-Frank Act is massive. Carney wrote a note on a totally different title that I don't know a lot about, but for the purposes of this note and this presentation, Dodd-Frank Act first created another agency called the Financial Stability Oversight Council, the FSOC, and it's supposed to identify systemic risks and respond to emerging threats in the United States market. The other thing it did, pertinent to this note, is it passed Title IV, which dealt with private funds. And the Title IV of Dodd-Frank has two overarching goals or barometers. One is to provide better protection to private fund investors from the private fund advisors. And the second is to assess systemic risk posed by private funds. And so who has to register now because of Title IV of Dodd-Frank? Private funds, including hedge funds, have to register if they're managing over $150 million of assets. And so it does away with the whole one fund, one client exemption that I was talking about earlier. If the hedge fund has over $150 million assets under management, you have to register. And there's a few exemptions. One's a family office exemption, which excludes extremely wealthy families and their professional advisors that are operating like a hedge fund or private fund. Another is a more narrow venture capital fund exemption that we're not going to get into. And another is a really narrow foreign fund exemption that we're not going to get into as well. So how does Title IV go about promoting their first goal, which is investor protection from these private fund advisors? When these hedge funds, over $150 million assets under management, have to register with the SEC, they have to provide certain information to them, including investment advisor's business, their ownership, certain clients, employees, and disciplinary events. A lot of these are related to fraud, and when the SEC sees red flags, they can investigate, although they do admit that they have scarce resources to do so. Now, Goal 2 of the Title IV of the Dodd-Frank Act, which is data collection related to systemic risks around hedge funds. hedge funds have to now, or registered hedge funds with the SEC have to fill out a Form PF, and this form breaks hedge funds into two groups. One is 150 million assets under management to 1.5 billion, and the rest is 1.5 billion assets under management and over. All the funds have to give information related to stuff like net assets, aggregate value of its derivative positions, use of leverage, even investment strategies. But the larger funds, the $1.5 billion or over, have to give even more information on securities, asset classes, and leverage. And they also have to report quarterly. Why do the larger funds have to provide more information? The SEC estimates that the $1.5 billion threshold will capture over 80% of the U.S. hedge fund industry. All this information is supposed to remain confidential, and the SEC is supposed to set up ways to ensure that. And then what does the SEC eventually do with this information? They pass it over to the newly created Financial Stability Oversight Council, the FSOC. The FSOC then takes the information that's related to the systemic risk of hedge funds, and then they take a wait-and-see approach. They see if there's any issues, and then they make recommendations to other agencies like the SEC, or if it's really bad, they can get the Federal Reserve Board to actually supervise these funds. So, what analysis and recommendation does my note provide about all of this? Well, I say that hedge fund advisor registration is unnecessary to achieve those two overarching goals of Title IV. So we'll go into the first prong, which is hedge fund investor protection. So why is hedge fund advisor registration unnecessary to achieve this? Or why is it unnecessary in general? First, people investing in these hedge funds and these private funds are still extremely sophisticated and affluent, either people or institutional investors. So a lot of these institutional investors are still demand a lot of information from these hedge funds before they'll even invest. Two, we have that 2007 anti-fraud hedge fund rule that was still passed and has that lower standard, that lower negligence standard, which provides a serious disincentive for hedge fund advisor fraud. Three, the SEC admittedly has limited resources. And four, for the smaller funds, there are serious compliance costs associated with this. And then lastly, although the financial crisis, the reasons behind the financial crisis are not completely sorted out, I haven't found anything that said hedge fund advisor fraud had anything to do with the financial crisis. So I just think this is just kind of unnecessary to throw in here. So moving on to prong 2 of Title IV of Dodd-Frank, the systemic risk data collection from hedge funds. Why is advisor registration unnecessary for this? Well, first of all, I think that collecting systemic data, or information related to systemic risk with hedge funds is completely logical. Most of the data coming from these hedge funds actually comes from the industry itself through surveys, so it's really opaque. So there's a gap in information. So my point is you just don't need to have these hedge fund advisors register with the SEC in order to collect information. Why can't the newly created Financial Stability Oversight Council just collect the information without having to register with the SEC? Then you give it to them, and then they give it to the FSOC. So, in summary, what are my recommendations? I don't think hedge fund advisor registration is necessary for the Title IV's goals. But I do think collecting systemic risk-related data is logical. So while the note doesn't suggest a threshold, I suggested that a threshold is reached based on size because that largely correlates with systemic risk. And if it's the $1.5 billion threshold that captures 80% of the hedge fund industry, for example, that'd be fine. I say once you set this threshold, you shouldn't exempt anybody beyond it, because then it would be under-inclusive. And this really goes to those family office funds exemption that I was talking about, where they're extremely wealthy. Families have hedge funds. The example I used was George Soros had recently kicked outside investors to the curb in one of his $25 billion hedge funds. because he didn't want to deal with all this registration. An argument I raise is, how does George Soros' $25 billion hedge fund not pose any less systemic risk than another $25 billion hedge fund? So that's why I wouldn't want there to be any exemptions after the threshold set. But anyway, that's the reasons I think hedge fund advisor registration is unnecessary to accomplish the goals of Dodd-Frank's Title IV. So, thank you.
All right, I want to thank so much everybody for the invitation and for putting together such a great event. I think this is a tremendous opportunity both to read a great piece of scholarship by an emerging scholar and financial services counselor that is obvious through this piece, and also a great opportunity to learn more about an issue I've been thinking about since I was in law school. I have to say I really enjoyed reading this piece, and I want to give him the best compliment I know how to give, which is that Luke reminds me of myself, and it reminds me of my own work, because I actually say that a little bit tongue-in-cheek, not completely, but I began working on this topic around the same time when I was graduating from law school, and at that time the first hedge fund registration requirement was just recently overturned by the D.C. Circuit. So I wanted to write about that. I was curious about that. Well, I was clerking in Delaware, where Luke's going to be clerking. I spent some time writing about it, thinking about it. And I called up a law professor who had written about hedge funds, the only one at the time who had written about hedge funds. And I said, hey, I'm just, you don't know me from Adam, but I want to talk to you about this. And I was amazed at how he actually took an hour to sit down and talk to me and talk me through my ideas. And he's now, Troy Paredes, he's now a commissioner on the SEC. And he actually was there for the hedge fund rule and voted against the rule. But I appreciate now what a difficult thing it is to get folks to comment on your work. So I think that's why this whole setup is really tremendous. Just to tell a little story about what I think Luke is up against. I was on a panel with the director of investment management for the SEC talking about hedge funds, and he said, "We got to regulate these things." And I said, well, let me just get a clear articulation of why. Why do we have to regulate it? And he said, well, they're managing trillions of dollars and they're unregulated. So let me get this straight. The main reason why we have to regulate them is that they're unregulated. He said, yeah, of course, obviously, yes. And I said, well, if I came to you and I said, let's deregulate some aspect of the financial services industry because it's regulated, would you tell me that I was ridiculous, that my argument was kind of vapid and empty? He said, well, of course I would. And I said, well, how is it any different to say that we should regulate because it's unregulated? And that's why I think this is a tremendous piece of scholarship. It does a great job of laying out all the institutional details of how hedge funds work, which is something you need to know to appreciate Luke's policy, very bold policy suggestion, and his analysis of the legal regime. He does a great job with how the securities laws have evolved to exempt hedge funds and how they've changed. Something that I've seen hedge fund lawyers mess up from time to time because of all the intricacies of it. And so I think it captures the issue and it tees up a number of policy questions that Luke does a great job of engaging with. I just want to offer a couple of suggestions for continuing to build on what's already, I think, a tremendous piece of scholarship to fill the time. But I think this is great work, and I offer suggestions solely in the interest of building further what I think is an extremely firm foundation. I would push him to do more to bolster the argument of what role hedge funds had to play in the crisis, because I think that's a key part of his thesis. And he addresses the allegation that Bear Stearns ran hedge funds that were involved in the crisis. But I think he can go further with that and look into all the other. If advisor registration is the solution to Bear's hedge fund role in the crisis, then what about the fact that Bear Stearns was registered under the 33 Act? It was a filer under the 34 Act. It also was regulated under the Consolidated Supervised Entity Program. Its capital was regulated by the SEC. So there's at least 3 regulatory avenues the SEC had over Bear that are each much more intricate and much more involved than this investment advisor registration provision. and just kind of work with that to build what's already there, and also to mention, I think it's worth mentioning, on the systemic risk side, I think that's an issue, and on the investor protection side, if hedge fund registration is the solution to investor protection issues, you got to make sure to mention that before mandatory registration, hedge funds could voluntarily register. And guess who was voluntarily registered as a hedge fund with the SEC, as an investment advisor? Bernie Madoff. Bernie Madoff. So I think you've got to mention that. Not only was he registered with the SEC, but in fact the SEC had come to examine his fund on multiple occasions over a decade as a result of multiple complaints, and failed gave him not only a seal of approval, but invited Bernie Madoff onto an investment advisor committee to advise the SEC on hedge fund regulation. I think it's a story that's dying to be told in your piece, and it's a story that I think even further bolsters the argument. What is investment advisor registration designed to address? I think it'd be interesting to add some discussion of the political economy, of the choices that are made here. One of the things that surprised me the most about this issue, I spent some time testifying on the Hill and trying to kind of politic this thing as it was going through the Congress, is that I thought that I was a supporter of the self-regulatory alternative, right? The self-regulatory organization alternative, because I thought it could work. I've since become a little bit skeptical of that, but in any event, I was shocked that the hedge fund industry itself was a big supporter of mandatory registration. I thought, why would that be? Why would they support? I would think industry likes deregulation, right? And the best explanation I've come to find is that very large incumbents tend to love regulation because it keeps competitors out. It's a rent-seeking sort of story, a political economy, public choice story, and I think that your alternative would run up against that potentially, or maybe not. And I think it'd be useful to talk about how feasible it is based on the political economy challenges it'll face going forward. Another thing I think you have to mention, just as you talk about investor sophistication, I think rightly so, as a justification for why they should be unregulated, the fact that they're solely invested in by sophisticated, large net worth investors. Paris Hilton being maybe the one exception to the idea that wealth is a proxy for investment sophistication. But in any event, it is an overriding element of securities laws. But I think you have to mention the Jobs Act that just passed. And you face a timing problem because the SEC hasn't done all the regs under the Jobs Act. But one of the things they do is lift the general solicitation ban. They're supposed to anyway under the Jobs Act, though the chairman's dragging their feet on that one. It means you'll still have only sophisticated investors investing in, but it means that because of more unsophisticated investors can learn about it and maybe sneak in to some of the funds that might take small retail investors. Just an issue worth at least addressing, even if you want to quickly get rid of it. I think you do have to make a choice in the piece about whether you think it's legitimate for the SEC to have any systemic risk role or not. And when you do make a strong argument for why, either you do, because you think that they have some capability, some relative capability over the Fed or over FSOC, or you don't. If you don't, however, if you think it should all be FSOC or the Office of Financial Research, then I wonder why you're still focusing on only large size, right? If size is about systemic risk, and if the SEC shouldn't be involved in systemic risk, then why do you focus on size in the proposal that you've got in place? Just a question I want. I'd like to see what you do with. Also, there's some discussion you might incorporate or might not about whether systemic risk is a function of size or it's a function of interconnectedness, or both, to the extent you want to give the SEC some role in systemic risk regulation. And I think one thing one question I have about SEC registration is the proponents have said, well, look, this is just investment advisor registration. It's the lightest thing the SEC does. It's not. There's a big difference between investment advisor registration and investment company registration, the 240 Acts. One says, you're a mutual fund, you can only, and it very much micromanages your business. One just says, I'll file some stuff about who you are and the assets that you have. So the hedge funds are now under the first regime. But I think there's sort of you break it, you own it philosophy of regulation. I think the next big crisis, whether it's an investor protection crisis or whether it's a systemic risk crisis, the SEC will be asked, why didn't you do more? And they'll say, well, we just had advisor registration powers. That was it. And the response will be, okay, well, then let's give you more powers. So is investment advisor registration a prelude later to Investment Company Act type regime? And if so, it would destroy the hedge fund industry. I mean, it would mean no more leverage. It would mean micromanagement of trading strategies. I think it would have even more significant consequences than we've addressed. So I think it would bolster your argument for some sort of limit. And then just a final point is, as a product of compromise, the SEC has divided authority with the states for smaller funds. So I think one thing, if we went through with your proposal, we could end up having is we could have very large funds registered with the SEC, very small funds registered with the states, and then a donut hole in the middle. Maybe that's good, maybe that's bad, but I think you should think through the effect of that. It could be nothing more complicated than just saying, well, let's get rid of the state regulation too. But those are all just thoughts that I want to have something to say in 10 minutes, so I try to put on whatever I have that I hope can be useful and I hope can add to what I think is a tremendous piece. What I think indicates to us the start of a brilliant career as a lawyer, financial services counselor, and scholar. And so I'm just glad to get a little window into the beginning of it. And really proud that you'll be clerking in Delaware, or I clerked. In fact, I have to just close a little story. That Luke's judge, I clerked for a different judge, but his judge is the Chief Justice. And I got to be friends, and he has a porch, and he likes to drink bourbon and smoke cigars on the porch. And if you're really lucky, he'll invite you to go there with him. So every week I would show up late. I would often show up late. Later in the clerkship, it's sort of like 3 a year, So I would show up late sometimes, and my judge would go, "Why are you late again? What's the matter? What are you doing?" And I was like, "Well, I was out, smoking cigars and drinking bourbon." He's like, "What? That's crazy. Who were you with?" And I was like, "The Chief Justice." And he'd be like, "Oh, okay. Well, I'm glad you made it in. Thanks." So you're in for a tremendous time, and I know the Chief only chooses people with smarts and with character, more importantly. So I think that's going to be tremendous. Glad to have this opportunity, and look forward to watching your career develop.
Well, I'd like to join in thanking Carney for her tireless work in putting this together. I've organized academic conferences, and there's a lot of invisible work that takes place behind the scenes. I'd also like to echo what Hal Clark said in his introductory remarks about the importance of this occasion as a way of celebrating all of our students' achievements in scholarship, even as we honor these particularly notable student works. Now, I've spoken at enough academic conferences after 5 o'clock to know that just about everybody in the audience appreciates strict adherence to the adage, brevity is the soul of wit. So I'm going to try to be brief while still doing justice to Luke's piece. Professor Brunner touched on this in his remarks. Luke takes up a piece of legislation that is not a standalone piece of legislation. It is a part of a very complex financial thicket. And he has somehow navigated, with Professor Brunner's help, through his way through that thicket while a second-year law student, which I think is remarkable. The hedge fund industry is also a very important industry. Whether you love hedge fund managers or hate them, they are very important market actors. The hedge fund industry is growing in public scrutiny, and I think it's fair to say public suspicion. We are more suspicious. Whether we should be or not, we are. I think a couple of cultural markers about this are, first of all, the recent movie Arbitrage. If you haven't seen it, I suggest you see it. Richard Gere portrays a high-flying hedge fund manager. You may recall Richard Gere, if you're my age, in the 1980s, he was the American Gigolo. I guess in 2012, he's something like the financial Gigolo. But he portrays a man who, for the first time in his life, is in deep trouble. And also, for the first time in his life, he's actually troubled by some of his poor choices. I think the other notable emblem here comes from the criminal prosecution bar in its remarks that were made by the United States Attorney for Manhattan in July, where he used humor to make the chilling point that he is watching hedge fund managers. Here's what he said. I know that the organizers told me that there were going to be a lot of people from the hedge fund industry here. I didn't quite appreciate how many people, so I just want to apologize in advance that I do not have enough subpoenas for all of you. Now, after the laughter died down, he says, obviously I'm kidding. I do have enough. Message received. I think that Luke's thesis here is as unmistakable as it is provocative. The hedge fund regulation that we got in 2010 is not necessary. It's not helpful, and it should be modified. What I'd like to do briefly is try to place Luke's subject and views into a larger perspective and suggest that the new hedge fund regulation, it is new, raises yet again the usual concerns in U.S. financial regulation, some timeless concerns, and they are, does advancing the investor protection rationale, does it also necessarily advance capital formation and concerns about the public interest? And in fact, aren't these worthy policy goals sometimes inconsistent with one another? Well, let me start with investor protection and then move to systemic risk. Luke faults the investor protection rationale of the 2010 Act. In effect, he says, I search in vain for the connection between the 2008 financial crisis, the ensuing concern about systemic risk, and the need to protect investors in hedge funds. And I think he rightly searches in vain because I don't think there is a connection. He tells well the drubbing that the SEC took in prior efforts to regulate hedge funds. Without being sardonic about it, without meaning to underestimate the cardiac arrest that SEC people were feeling, like all of us in 2008. This was an unexpected and in many ways serendipitous regulatory opening. The regulatory iron in Congress in 2010, and Hal Clark could attest to this because he lived through it, was hot. There were villains and victims aplenty. Regulatory nuance was in very short supply, and the SEC struck. And we got the regulation that Luke faults. Now, even apart from shrewd political timing and implausible policy connections to investor protection, I just want to suggest that there might still be some points to consider in favor of investor protection. I think there might be several, but I'm just going to touch on three. First, I think the new regulations, notwithstanding that the SEC does make mistakes, and of course they were embarrassed by the story that J.W. tells, but I think notwithstanding some mistakes, I think the new disclosures coupled with on-site examinations will allow the SEC to learn a great deal about funds, such as some basic things. Are the assets actually of the kind and amount reported? Are the assets safe? And how are you valuing your assets? Is fund performance, the valuation is enormously troubling because there are not uniform ways to value these assets. Is fund performance as you described, and do you appropriately handle conflicts of interest? I think a tough financial cop can not only punish wrongdoing, I think the presence of a tough financial cop can deter some wrongdoing and possibly through the raised regulatory eyebrow serve to upgrade industry practices. Second, I'm not as confident that the current anti-fraud rule really does the trick. And just to draw a brief parallel, in the 34 Act, we have the infamous Rule 10b-5. But I don't think people suggest that that anti-fraud rule should supplant or replace the other extensive disclosure requirements of the 34 Act, rather than simply supplement them. And finally, I think we have in the United States securities regulation sort of ongoing myth. And that's the myth of what I call the sophisticated investor. The behavioral and regulatory premise is that if you're relatively well off, you have $1 million in net worth, or you make $200,000 a year, that you can fend for yourself. You can self-help. I think besides being more attractive candidates for a good financial fleecing, are we really sure that wealthy investors are as shrewd as we think? Or are we just saying that we're really not that concerned about them as a matter of public policy? Not something anybody in a democracy wants to say. Returns on hedge funds as a class, taken in aggregate over time, are pretty mediocre. There's some extraordinary exceptions. There's some eye-popping returns in certain sectors, certain mavens, certain funds, but not year in, year out across the sector. If investors are not uniformly savvy on this front, are they really so savvy in protecting themselves from wrongdoing? I think this concern will only grow worse because of the Jobs Act that J.W. touched on. Because the SEC, in sort of one of its typical lurches, you might use the word flip-flop, went from a very strong investor protection policy in 2010 to reversing course in 2012 and saying, we need to emphasize capital formation, and essentially mandated that the SEC drop its long-standing prohibition against general solicitation and advertising. Now, I'm not suggesting that hedge fund managers are going to run infomercials at 2:30 in the morning for those people who can't sleep, or that they're going to run ads on ESPN or primetime TV touting their products the way the latest cell phone plan is marketed. But I do think there are a couple of concerns. I think because essentially you can now conduct a public offering. Even though we still call it a private placement, it's essentially a public offering because you can advertise. I think no matter how stringent the manager's investor qualification procedures are, inevitably, unsophisticated people are going to slip through the nets. But even for those people who are accredited and deemed sophisticated, I'm not sure that with a broader pool who heretofore have not gone into hedge funds, being lured in, not sure those people really appreciate certain things about hedge funds. They use leverage. They're very difficult to exit. And valuation of assets is not for the average investor. Now, however we land on this, what I like about Luke's piece is he places hedge fund regulation, which in some ways is unique, into this larger ongoing debate. I think he does a really good job of setting up any ensuing discussions that may come out of this data collection. Now let me turn briefly to systemic risk. Luke is definitely more positive on the systemic risk concern. He thinks it's valid, but he still doesn't think regulation is needed because the data can simply be sent directly to the FSOC. Let me make two small points here and then end on a larger concern. The concern that information time lags can mean that fund data is routinely stale. Will the data really be fresh enough to head off systemic risk concerns? Now, I know there's a duty to update, but a hedge fund manager who is under siege with a fund performance is maybe not going to be quite so alert to saying we've got to update our stale report. So I'm not sure that the data is going to be all that timely. Second, are the SEC and FSOC truly capable, administratively, of handling all this data? And perhaps more disturbingly, are they really able to interpret it, to discern whether disturbing systemic trends are emerging? I'm not sure that financial forecasting has reached the state of art that we have even in predicting weather, where more and more we get it right, that a storm is on its way. I think forecasting systemic risk may be a little bit like relying on grandma's arthritic knees to tell us whether a storm is coming. I'm not at all convinced that they're going to be able to tell us what they make of all this data. Now, we've got to find out. This is information to be learned. But we know one thing already. We know that funds need investors. And investors supply the very capital that may cause systemic instability. In other words, no investors, no funds. If there is systemic instability, it may actually be financed and fueled by investors. Now, this story, if it's a good story, if it emerges as a story, is not the story of fund managers versus investors. It's a story of funds and their investors versus the public interest. What is frankly good for some, maybe many, hedge fund investors may not be consistent with the public interest. Now, fortunately for us, Dodd-Frank can sidestep this issue. Because at the end of the day, all Dodd-Frank really does is mandates the collection of data for further study. As a result of that study and more information, it may be that Luke's investor skepticism is justified. But it also may simply serve to spotlight the way in which, even if funds don't hurt investors as such, fund interests and those of its investors might clash with larger societal well-being. Now, I hope that conflict does not arise. It would be an awkward and difficult conversation, and one that I don't think we're ready for. But I want to end by again applauding not only Luke but Claire for outstanding presentations, outstanding work. It's a privilege to be a part of this occasion. Thank you.
I am not Dean Demleitner, but unfortunately the Dean is pulled in a lot of different directions this weekend with the Law Council in town, and she couldn't be here to deliver her closing remarks. So that leads to the nightmare that is me standing up here talking in front of you. But as Professor Johnson has already pointed out, we're well past 5 o'clock, and I won't say anything that I don't absolutely have to. First of all, on behalf, for Luke and for Claire, on behalf of the Volume 70 board, we could not be more proud to publish your two notes in the first issue of Volume 70. It's just, I had an opportunity to read both notes, and I found them riveting, and I think Dean Demleitner asked me to say that she also had an opportunity to read both of them and enjoyed them both immensely. So we couldn't be more proud of you guys. Congratulations on winning your awards. Second, I'd like to thank the Law Council and specifically Mr. Clark for being here to introduce this event. Without the Law Council, these awards wouldn't be given and this event wouldn't be possible. So certainly a big thank you to the Law Council. We look forward to continuing to work together to honor great student-written scholarship. Next, I would like to thank Professors Stefan and Verrett for coming out here, being here in person for this event, and also for lending their voices and thoughts to be published along with the notes in issue 71. And we look forward to seeing the final product.
On time.
For Professors Johnson and King, also for taking their time and lending their voices to this, and also in print. Finally, I'd like to thank a few people without whom this event never would have happened. I'd like to thank Professor Wilson, without whom Professor Stefan and Brett wouldn't be here. I'd especially like to thank Lisa Gerhardt, who put the drinks in your hands, the cookies in your belly, and the programs in your hands as well.
And finally, last but certainly not least, I'd like to thank Carney Simpson for all the work she did from start to finish and the millions of details she was on top of all the time in planning this event. Finally, one last thing, just looking forward, we hope that everyone here joins us again in a couple weeks for our symposium on November 8th and 9th. We're very much looking forward to that. And looking even further out to next year, just looking out at the 2L class, that's our staff writers right now, there is a person among you who will be Carney, will be in charge of putting this whole event together. There is somebody who unfortunately might be pressed into service at 6:30 to say a few remarks. And there are two of you who will be sitting in these chairs, the proud recipients of these awards. And after having read all of your note proposals over the last week, I can't wait for that to be the toughest decision of the Volume 70 board. So thank you, everybody, for coming out, and enjoy the weekend.